My name's Aaron Solomon. Thanks for coming today. This is the secret sauce track, right? So since we are both from Louisiana, we'll call this a ramelade, right?
No, there you go.
There we go. All right. So I don't know that Mike needs much of an introduction, but we'll rattle off a few for him. So 2004 Trial Lawyer of the Year, 2014 California Lawyer of the Year, rated top lawyers in California every year. Dozens of multi-million-dollar verdicts, like 48 million, 29 million, 33 million. The largest verdict in our home state of Louisiana ever, 29.1 million. Yeah. Not bad. So, but more importantly,
At the time. All
right. So we're here to talk about deposition. So this man maintains a digest of 9,000 plus depositions. So you need the dirt on a allegedly dirty defense expert. This man's got it. So without further ado,
nope. Thank you.
Roll.
So go Tigers. We're both LSU alumni, and in fact didn't know each other till we moved out to the West Coast and then connected through LSU networks, and here we are talking together. Do y'all want to learn some shit? Because I got some shit to talk about. But I'm going to talk about depositions, but I'm going to talk about how to kick ass in depositions. Right? I'm going to talk about how you get people to tell you what you want them to say, right? How you can get to a point where you ask your associate, what do I need to get out of this guy? And they give you 5 points and you go get it. You want to know how that is? I want to talk about first energy, right? Everybody's here you came to this to network. You came to this room to learn, to hear me talk. So you got to do what I say, okay? All right. So what I want everybody to do first is to the person on your right and your left, I want you to meet them like they're the most uninteresting person you've ever met. Ready? Go. Just uninterested. Not interested. Not interested. All right. Now you are the most attracted to this person, and they are the best referral source. Now introduce yourself. All right. Well, shit. Everybody's like, screw you, Mike. I'm going to talk to this guy. You felt the difference in energy? You know, the only difference in that energy from one to the other is what I asked you to do. The first thing I asked you was a negative, and the second thing I did was a positive. And just with that change from negative to positive, you felt how the energy changed in the room? Right? So people think that to be a badass trial lawyer, to be a badass depo taker, you got to be a son of a bitch. You got to scare people into talking. And I am here to tell you that that's not true. Right? If you know the law and you know what you can and can get away with legally, and you know techniques that I'm going to tell you about today, every one of you can be an amazing depo taker and do it in a positive way where everybody leaves thinking that they didn't tell you shit and you just won the case, right? Now, depositions are really, really important, and I teach this at Loyola Law School, and I tell law students and I tell lawyers, depos are the most important skill in litigation times 1,000. People are like, Mike, when's your next closing? I got to come listen at closing so I can run my litigation practice. And I'm like, what? 98% of your cases will never need a closing argument. 98% of your cases will never need the depo that you took to read it at the trial. Right? So why are depos so important? Now, everybody thinks it's because you get information and you pull people down and get them to commit. But that's only part of it. Depositions are so critically important to convey to the carrier, to the defense lawyer, that you are moving your case forward. You can notice depositions 20 days after you serve a complaint. Our firm notices the defendant's depo and a PMK 20 days after service. Now, they usually then say, well, you've unilaterally said it, whatever, but I just set the tone, right? But why do I want to get to that depo? Because usually if it's an important depo, after that deposition, the defense lawyer is going to write to the carrier about the quality of your case and set reserves. So how you present, not necessarily what you get the witness to say, but how you look, how you act, how clean your conference room is, how good your coffee is, whether you have half and half or powdered creamer, whether there's another depo going in the room next to you, whether you're starting to take in-person depos now again rather than just remote, because remote's easier, but in-person's a much more effective. Whether you videotape your depo or you don't, all of those things convey something. And then when the defense lawyer knows that you know what you're doing, then you know the law, you don't take bullshit objections. I'm going to show you how to shut those down. Then when they write that letter to the carrier about your case to set the reserves at either $400,000 or $800,000. Now they don't write in that letter, the plaintiff's lawyer is really fucking good, is going to kick my ass. They don't do that. You know, the plaintiff makes a really good impression, and this is a really good case for the plaintiff, and I think we're going to need to put some more money on it. But the reason they're doing that is because, in part, how you portray yourself in a deposition. So the topic here is, I think officially, what? What not to let happen?
I believe so.
So I want to talk generally, then we'll ask questions, and then I'm going to give you guys some techniques, okay? Now remember, we're now set a depo in a beautiful conference room with none of the boxes in the conference room, or it's on Zoom and you actually have your background that's not fake, but there's no garbage in the background. You're not in your closet. You're not, anybody ever taken it? Everybody seen that?
Oh, yeah.
Right? I'm like, dude, are you in your fucking closet? What? If it's in person now, that Starbucks coffee with a creamer, I went and bought it. We bought a little carafe. We have half and half. The defense lawyer in a big case just a couple of weeks ago is like looking for creamer and they're looking for the powder. And I'm like, no, it's in that carafe. They're like, what is that? I said, that's half and half. I'm like, yeah, we're big time, baby. But that means something. Now, I'm not saying that that's all of it, but these things add up, right? How you dress. When I started, I wore like a 3-piece suit with suspenders and I'm like, yes, sir. And then I thought I was cool, and then I'm like wearing ripped jeans and I realized now I'm back to suits because I realized that what is most important is about that presentation so that when I go to get the information, all of that works well together. Now, I'm not criticizing anybody if you go in and you're wearing your boots and your jeans and your ripped shirt. But I think in general, clean conference room, good coffee, pleasant reception. If you have awards or whatever, put it up in the reception area because the defense lawyers not only read them. You ever seen defense lawyers taking pictures of the awards? Oh, I got a whole wall of shit, and the defense lawyers just like, you know what they're doing? They're attaching them as exhibits. In that letter, they write to the carrier right after the depo. So, 2 big things to be a good to great to awesome depo taker. You got to push for an answer. And that requires you to understand what you can get an answer to. You push And we'll talk about some examples.
Emerson?
Huh? Well, we'll talk about the law too, right? And then second, you got to know the rules and what can happen and what you're allowed to do. And with those two things, stepping outside your comfort zone and pushing for an answer, not accepting the bullshit, I don't know, I can't, I don't remember, whatever. And then the last thing before we talk about the techniques, before I forget, is the admonition. Now, y'all know what an admonition is, right? The admonition where you hear the defense lawyer and they're like, before we ask questions, I want to talk about, you have to estimate, not guess. What that means is if the length of this table was here and you went into my table at my house, you wouldn't be able to know. And that's a guess. And you understand the difference. And, you're under oath. And, the whole reason we do that and they do that at the beginning of the depo is so that if at trial you read the depo, which only happens 2% of the time, then that witness goes, oh, you know what? I didn't understand the deposition process. So you're prophylactically protecting against something that I'm 110 trials in and it has never happened. So the first thing I want to say about the admonition is don't use it as a shield. Let's now make it a sword. So don't give your admonition at the beginning of a depo. You give it when the deponent says something that's not accurate. And usually it's a difficult question and they say, I don't know. I don't remember. Now let's use that same admonition as a sword. You ask a question, they go, I don't remember. You know what? Let me take a step back. This is a deposition, unlike a conversation in the social atmosphere. So, like if I was at a party and I came up to you and I asked you that question, you would say, if you didn't want to answer me, you'd say, I don't know. But this is a legal proceeding under the penalty of perjury. And you don't get to say, I don't know or I don't remember. If there's anything that you remember or anything that you know, you don't get to not tell me. If you're not sure, tell me you're not sure. But because you're under the penalty of perjury, which is different than real life, you must tell me every single thing you know. And then you do the kicker, including the stuff you don't want to tell me. And I'm going to ask you by the end of today some questions that you are not going to want to answer, that are going to make you uncomfortable. But you understand that because this is not like real life, and this is instead a legal proceeding under the penalty of perjury, even though you don't want to tell me, even though you think it might hurt someone else, you got to tell me everything. You understand that? See how much more effective that is? When did I use that last? An elder abuse case. Miss Nurse, isn't it true the doctor falsified the records? Well, I don't know. Ma'am, you remember what I talked about those times when the question's going to be really uncomfortable? This is one of them. You remember we talked about under the penalty of perjury? So let me ask you again. In this deposition, which is a legal proceeding, did the doctor falsify the records? And they always say, well, if I have to answer under the penalty of perjury, yes. So admonition, sword, not shield. Make sense? All right. So I'm ready to roll. I'm like,
You got to button that top.
okay. All right. So the first thing that I want to talk about, not letting the defense lawyer get away with, okay, is speaking objections. Now, the law in a deposition is that you are required to make form of the question objections in a deposition, right? Vague, lacks foundation, calls for speculation, compound. Because the theory is there's no judge at the time. That's going to be later at trial if it comes up. And you want to let the questioning lawyer know that you think that the question's not clear, and now you're giving the questioning lawyer the option to rephrase, right? That's the reason for the objection. That's it. Objection relevance. That's a bullshit objection. That's not a form of the question. Calls for a legal conclusion. That's not a form of the question objection. Form of the question objections are the ones that are made in a deposition. So we have these speaking objections of objection misstates the testimony. Done. But they don't say that. They go, objection misstates the testimony. What the witness said was da-da-da-da-da-da-da. So I want you to feel very comfortable that one, the other side absolutely is required to make form of the question objections. Vague, lacks foundation, compound, calls for speculation. But if they go further than that, cut them off. If they go further than that, call them out. Right? Now, depositions are about a process. And if you're a young lawyer against like an old curmudgeonly defense lawyer, that person's going to try to abuse you and do all this stuff, right? Well, when you were an apple in your mama's eye, I was taking depos at whatever. I'm like, maybe it's time to retire, but you know. But the point is that once you know the parameters, you don't have to win every argument, right? But as you start to set the tone, then when you come back to it again, the defense lawyer has learned their lesson. So the first thing, form of the question objections only. If they go further than that, cut them off. Don't cut me off, counsel. I get it. You understand form of the question, objections are the only thing. Don't tell me the law, counsel. But remember, we're being positive, right? We're like, gotcha, man, let's go. They may do it again. I'm like, please, no speaking objections. And especially if the witness then says exactly what the lawyer said to say, point it out. There are no rules here. You can do it in whatever way you want, as long as you follow these general rules. Okay? Second thing, and this is the most important thing I have told people ever in the history of taking depositions. A defense lawyer is only allowed to instruct their witness not to answer a question based on privacy and privilege. The case, Stewart versus Colonial Western. Madam Court Reporter, that's Stewart. Because by the way, if you can spell cases, it freaks the shit out. The defense lawyers, judges, I teach this and I make my students every night spell the cases. And every time they say something, I'm like, you got to spell the case. You don't realize how silly it is when they're drinking their beautiful cup of coffee with creamer. They can see a beautiful conference room. There's a video in their face. And I spell a case, their mind explodes. And I know it sounds silly. But if you can spell the case, you must know what you're talking about. And I don't want to look bad. And this depo is probably not going to be used this is not going to be a trial. So you know what? I don't want to look bad and just go ahead and answer the question. But the law is very clear. Stewart versus Colonial Western, that's Stewart, not Stuart. Private or privileged. In fact, relevancy objections are not even supposed to be made. Now, how many of you have been in a depo? Counsel, I'm not going to let my client answer that question unless you tell me how it's relevant. Well, counsel, you understand that relevancy is not a proper objection, and the only thing that you can instruct the witness not to answer is on privacy, grounds or privilege grounds. That's Stewart versus Colonial Western. That's Stewart. So is this private or privilege? And if it's not, then you just ask the question again. What's the answer? You just, right? Now, don't be a jerk about it, but you're being a accurate stating of the law to get what you want. Calls for a legal conclusion. You're at fault, right? Objection, calls for a legal conclusion.
Objection, Rifkin.
That's a contention question. But we're not.
How often do they misunderstand that difference?
I don't think it happens very often. And I'm not talking about Rifkin because that's like an exception to an exception. So here's start a depo. Mr. Defendant, good morning. How you doing? Great. You were at fault for this accident, right?
Yes, Facebook.
Yeah. Oh, shit happens all the time. Objection calls for a legal conclusion. He's not a lawyer. You're at fault, right? Objection, counsel. So you're not at fault. Now see, I'm pushing, but I got an answer, right? And I can get an answer, even if it's, I don't know if I'm at fault, because the defense lawyer is not allowed to instruct them not to answer because that's not a question of privacy or privilege. But see, now if I push and I'm allowed to get answers, let's just take it, all right? Sir, you're at fault for this accident, right?
No.
You're not?
Absolutely not.
Well, was there anyone in the car other than you?
Yes.
There was?
Yeah.
Well, you're not giving me this. We're talking about. Well, so you're saying 100% you're not at fault.
No.
So is the plaintiff 100% at fault?
I don't know.
Well, was there anybody in the accident other than you and the plaintiff?
No.
So you don't know anything about the plaintiff. You just know you're not at fault.
Yeah.
Right? Well, I just got an answer, right? And he's not playing very well right here. But a lot of times they will say, I don't know, right? They want to get out of it. Now you can use your sword of an admonition, but also it really doesn't matter what the defendant says because what you're doing is you're getting cross-examinations, you're getting cross-examining information, but you're also, the defense is watching this, right? Now, somebody said when I went right for it, they went, ooh. Don't you think the defense lawyer is saying the same thing? But I asked y'all to talk and meet people. I've never done that before. But I said, you know what, I'm going to step outside my comfort zone a little bit. I'm going to step outside my comfort zone and go, you're at fault, right? Or ask those tough questions. And you can get answers, especially when you have like expert witnesses. Now, I know that, remember, when you have an expert depo, they're no longer represented by counsel. They waive they waive work product, they waive if they're a designated expert. But I want to use this same analogy. When you push, how many times have you heard defense experts try to avoid answering the question? Right? Especially when it's about bias questions. About how much money do you make? Anybody ever ask those questions?
Well, I don't know.
Okay, well, let's do it. Sir, you've been a designated expert for 20 years. How much money do you make on an average annually from MedLegal work?
Oh, I don't keep up with those things.
I get it.
In my office.
Of course, yes, sir. I'm pushing, right? Just a real big ballpark. Just give me a general idea how much money you make.
MedLegal work is such a small percentage of my practice, I just don't know.
Yes, sir. Thank you. That wasn't my question. My question is, can you give me any idea, even just generally, how much money you make?
I'll have to get back to you on that.
Well, sir, do you have any idea right now? Because as a designated expert, you're supposed to present at a deposition to answer all the questions that I'm going to ask you at trial. And by the way, I'm going to ask the jury this question. I'm going to ask you this question in front of the jury. So as we're looking at the jury, and I'm asking you, how much money do you make even generally on an annual basis? What are you going to tell the jury?
I'm gonna have to go ask my assistant.
Well, so now I've had this in trial where that a witness has said that. He keeps going, whatever. And then I'm like, and you push. Well, sir, have you ever filed a document with any governmental agency that says how much money you make? Well, are you talking about tax returns? Yes, sir. Have you read your tax returns? No, I haven't read my tax returns. That was a cross. I said, no further questions. Thank you. When the jury was like, you're a fucking moron. Right. But see, you see the power of Stewart versus Colonial Western allowing you to get answers from people who don't want to answer you, who are going to probably not tell you the truth or feign ignorance or lack of memory because they don't want to answer you. And your ability to push usually gives you the really good cross-examination. Now, you see what I did with the jury here, and I'm like doing that? I'm just making that shit up. But see, I'm in the rules. Don't talk to my witness and tell them that you're going to talk to the judge. So when I talk to the judge, I'm going to let the record reflect that Mr. Alder is standing up for this deposition. So stipulated. Just move forward. Because they're doing all this stuff that has nothing to do with the rules that allow you to act in a deposition. Make sense?
Yep.
Any questions on that stuff before we go to the next technique? Yeah.
For the tax returns, could you have used that initial privacy or privilege? Could you have said that I cannot disclose this because...
Well, I said it was an expert, and I'm jumping around. In an expert, you waive your rights. And actually, there is case law when you are a designated expert that you must provide that information if you make a certain amount of percentage of your income in the years past.
That's not stupid.
Hmm?
So that's not stupid.
No, that's Allen, Madam Court Reporter, Allen, and Stony, right? Stony Brook. That's Stoney, not Stony. You see how silly that looks? That shit is so effective. I got to tell you, do it with the judge. Got a seatbelt issue, Your Honor. The plaintiff's not wearing their seatbelt. Comparative fault. I'm like, well, Your Honor, you understand Truman versus Vargas requires that's Truman. Hey, thank you. All I know is how to spell. But they think I know a lot more. Right? God forbid if you memorize the case site, their mind. But see, the whole point is that, especially if you're a younger lawyer against like an old curmudgeon, they won't follow the law. They'll instruct them not to answer even when they're not following the law, right? That's fine. But you use these tools of spelling, of giving them nice coffee, of having a video, and then later on in the depo, you come back around. And a lot of defense lawyers learn their lesson. A lot of them learn their lesson, right? Yeah.
What would you do if they still insist on their client not to answer, even though you've given them the case law? What would you do at that point?
So the law requires you, it's not very helpful. You have to get the rest of the stuff from the deposition. You have to move on and ask your other questions and then move to compel. But if you believe that they're being, obstreperous for basic stuff, then you can suspend the depo and make a motion to compel. But remember, I just want to say, 98% of the time, it don't matter if you take that damn depo, right? So you suspending a depo and making a motion is probably more effective than finishing the depo, because 98% of the time, you're never going to need the depo because it's not going to go to trial. Right? So we spend all this time with tomes with every question conceivable, and you're freaking out. I forgot to ask. Oh my God. 98% of the time, who gives a shit? And that 2% of the time, just ask it at trial. But we spend all this time thinking about, are we asking the right question? And we're forgetting what the rules are and what we're trying to accomplish. Ultimately, we're trying to get more money for our clients, right? Most of the time, that's because you're making a good impression for the defense, and that's usually at a deposition.
If they're saying privacy, objections on privacy,
Right?
what would you do?
If they say objection, privacy, or privilege,
Yes.
let's try it. Are you at fault?
No.
Well, you say, well, that's private information. You say that's private information. So now you push. Well, what's private about it? I mean, do you feel like if you were at fault, that somehow you have some entitlement to not tell people about it because it's private? Objection, let the record reflect Mr. Alder standing up there. Am I in the rules? They could object on form of the question. But understand that your ability to get an answer, even if it's a silly ass answer, has a lot of power. Has a lot of power. And at trial, it's just great. So many times you get witnesses that don't want to answer your question. Right? And that's the best cross-examination in the whole case. All right.
Emerson next?
Yes. Next. Did you guys know that you can make a deponent act out stuff? Did you know that you can make a deponent write out a schematic? Do you know that you can bring a whiteboard into the deposition and have the deponent come over to the whiteboard and write the intersection? And you can make notes on your whiteboard as the person is giving you answers, and you can invite the deponent over to the whiteboard. And as you're going through, you're asking questions. Do you know that I've taken whole depositions standing up with me and the deponent at the whiteboard and the defense lawyer way over there? Can you imagine the control that you have, right? Imagine when you make your kids do something, you feel like you're in control, right? Why do you have to do it? Because I said so. Now you can say so. Emerson Electric Company, Emerson, says that you can make a deponent act out, like a bar fight. Show me how they punched you, right? Show me how your body moved. You can make them draw stuff. Now remember, you also have the ability to get them to answer the question. So, you know what? I want you to draw the schematic. Objection, my client's not an architect. Heard that? Object, let the record reflect this is not to scale. I'm like, I get it. Well, I can't draw the intersection. Now we're pushing, right? You can't draw the intersection. Have you ever drawn anything in your life? When you were a little kid, did you draw with crayons and whatever? I mean, even generally? So I want you to do the best job you can, but I would recommend you do it well because we're going to show it to the jury. So here, do the best you can. Well, let the record reflect Mr. Alder's harassing my client. He's standing up. I am standing up. You know what? Why don't you come up here? Let's go. And you can do that under Emerson Electric Company. That's Emerson.
Since we like telling stories in the South, why don't you give them your favorite or one of your favorite Emerson moments?
A good story in the South starts with, well.
The fish was this big.
You know what? I think a more favorite story because the idea of the whiteboard, and I don't know if any of you have whiteboards that you use in a deposition. I started that. I was in a case with like the Department of Public Works in LA, right? So I take the deposition of the assistant to the department head of the da-da-da-da-da. And then the next day I take the department head's assistant to the da-da, and I'm like totally confused. So the next witness, I bring in a whiteboard and I was going to have her write an organizational chart. So I start the depo and she's like wants to cut me, man. I'm like, can you state your name? I don't remember. I'm like, so I go up to the whiteboard and I'm like, don't remember name. Have you reviewed any documents to prepare for your deposition? I don't remember. Like, oh.
What's the document?
Don't remember. Right? And I go down And then I ask another question, and instead of answering me, the deponent goes, she don't want me to write on the board no more. And from that time on, I started using whiteboards. They become the word of God when you write stuff down. In trial, when you have butcher paper or something, oftentimes, and I've only been stopped twice from doing this, both by federal judges, because it's like, you're restating the evidence. But if you get something good, go write it up on butcher paper in the trial. But in a depo, you can use a whiteboard to emphasize important things. How many times, who was in the meeting? And they go, Billy, Bobby, all the new edition, the whole thing, right? You write them all up there, but now you have a note so that you go, okay, what did you talk to Billy about? What did you talk to Bobby about? So the whiteboard helps you organize. It also is a great prop. It gets you standing up. It gets you a place for the deponent to come to you. You have multicolored things that you can give him or her. And that all is control. It's all control. Totally within the rules. Okay? So what's my favorite story? This is something that just, two things. I talked about positivity versus negativity. In depositions, many times you get more with honey than vinegar, right? So I'm deposing this guy who had like inappropriate relationship with like 4 women in his office. And he is the biggest asshole I've ever met. He won't answer anything, right? So at some point I go, you know what? I really appreciate you. You seem hungry to me. A little hangry, actually. You know what? I'm going to go down to the cafe downstairs. I'm going to get some power bars. You want anything? The defense lawyer's like, what the fuck is going on? Like, huh? No, I don't want shit from you. I'm like, got it. So I go downstairs and I buy like 5 or 6 power bars. I come back, start the depo. I got a couple of flavors, man. So, you know what? In fact, that looks pretty good. So I'm taking the depo on a meeting, right? When he reached for a power bar, he was mine. Right? That's control, right? At the end of the depo, yeah, man, you're a great guy. I really appreciate it. I'm like,
You're going to have him act out some different
no, I didn't.
Sexual game.
And then the last thing is, and I'll take some, I don't know how much longer we have, but I'm here to answer questions too. A lot of people don't know what a Perry Mason moment is. Some of y'all know what a Perry Mason was. So there was a show way back called Perry Mason. What was the guy, the actor? Raymond Burr, right? And Perry Mason was a trial show where at the last part of each episode, he would totally inappropriate, outside the laws of all evidence and whatever. And it's true, sir, that you killed Mrs. Maple with the nightstick and the da-da-da. And then the witness would go, you're right. Oh my. Anyway, they called that a Perry Mason moment, right? And so if you have one of those in trial or a depo, right, it's called a Perry Mason, where they're like, you know what, you're right. I've been lying to you the whole time. You're absolutely, it doesn't come very often. But I remember way back when the Billionaire Boys Club, the 2 boys that shotgunned their parents in Beverly Hills. And I remember the prosecutor in that. He's like talking to one of the boys on the stand, and he's talking about premeditation versus non-premeditation. And the guy goes like, the boy goes like, I just walked in and bought the shotgun. I wasn't really even thinking about it. And so he's like, oh, so what store did you go to? Oh, and what was the front door like? Oh, and then you went in and he leads them down this path of 20 minutes and then says, well, did you know that they didn't sell guns at that store for another 4 years? But now he couldn't go, oh, I was mistaken. I must have been thinking about something else. Well, I had that happen to me in a depo, and I was remember. So an important manager who had all of the information in his phone texts. So I subpoena him, I do the depo, and I have him in writing bring his phone, and he shows up in the depot and he doesn't have his phone, right? And he's like, well, I didn't think I needed my phone. So now when you push, if you have someone that you don't think is telling you the truth, push him. So I'm like, what do you mean you don't have your phone? Do you? And he's like 28 years old. I'm like, do you normally leave your phone at home? Oh, yeah, sometimes if I don't need it. I'm like, really? I'm like, well, how'd you get here? Now he's lying. I'm like, didn't you use your phone to get here? No. Well, how'd you get here? Oh, I looked it up yesterday. I'm like, well, where's the printout of your instructions? He goes, oh, I memorized it and didn't bring it. I'm like, but you can't remember any witness ever. And you remembered how to get here. And I know he's like, you sure you didn't use your phone to get here? No. Like, what street are we on? What exit did you take from the freeway? Where'd you come from? I'm in Century City, San Bernardino. I'm like, you've never been here before? What's this big ass street right here? What's that called? How the fuck are you gonna get home? Break. Depends on Mike. My witness would like to amend his statement. I said, you got your phone, don't you? He goes, I used my phone to get here and it's in my car. Let's take a break, go get your phone. He's not getting his phone. I'm like, case settled the next day, $12 million. Right? But again, these are all pushing, all understanding the rules. The defense lawyer was shitting a brick, but I've known him and he knows what the rules are. He was objecting on, oh, Mike, that's not relevant, da-da-da. And I was just moving forward. Come on, Mike, you've asked him about his phone like 6 times. Let's move on. So your ability to be outside your comfort zone, to understand that a beautiful conference room, coffee, creamer, video in their face, stuff on your walls, how you look is important. Knowing what the law is and what you can respectfully get answers to is important. Your ability to step outside your comfort zone, because if you're uncomfortable, imagine how uncomfortable that damn witness is. Right? And understand that even under the worst of circumstances, 98% of the time it don't mean anything. So relax. Push, you will kick some ass. That's it. So I want to open it for questions.